Ms. Rivers, are you ready? We're talking about a different case right now. It's 25 SC 000816. It's State versus Mender and State versus Rogers. We have both young men out here with Mr. Francis on their behalf. We have Ms. Davis for the state. And before we dive into this any further, I'm gonna let you start, Mr. Francis, but I'll supplement as needed. What do you want to get on the record in terms of you representing both? You are Mr. Rogers's attorney of record.
That's
that I know. And Mr. Mender had Ms. Cabrera, a colleague of yours, as his attorney. Ms. Cabrera can't be here today, but you're here. She had told me that she spoke with Mr. Mender and that she saw no issue, especially since the defenses are not antagonistic and everyone is interested in entering a plea. And as I see what the recommendations are, shouldn't be all that controversial, but we still need to make a record that Mr. Mender is comfortable with you handling his plea and that Mr. Rogers has no objection to that.
Right. And you may recall, Your Honor, we put that on the record some time ago at a calendar call that we were in a business relationship together.
Yep.
And that we didn't see any conflict. There's no defenses in opposition.
No, I don't think there is in terms of you and Ms. Cabrera being counsel of record. I wasn't as clear as I should have been. It's the fact that Ms. Cabrera is not here today.
Right. And I've explained that to Mr. Mender, and I believe he wants to go forward. Is that correct, Mr. Mender? You want to go forward with me standing in for your lawyer?
Yes?
Yes.
Okay.
And you're okay with that, Mr. Rogers?
Yes, sir.
Okay.
Okay, great. Mr. Mender, if anything ever changes, let me know. But Mr. Francis is here as your advocate as well. And so if you have questions about what's going on or you're confused about something, you can certainly ask me. You should feel free to ask Mr. Francis as well. If at any point you start to feel like, well, wait, you're not advocating for me, let me know. I don't think that's going to be an issue based on how this is going to resolve and what I know about Mr. Francis's ability to articulate on behalf of both you and Mr. Rogers, okay? And Mr. Rogers, you have no concerns about Mr. Francis handling both pleas today? No? Okay, great. So to both of you, Mr. Mender and Mr. Rogers, I need you, when you're answering the questions, to make sure you answer verbally as well. You're welcome to shake your head or nod. Make sure you answer out loud and loudly so that Ms. Rivers can hear you. Ms. Davis is going to swear you both in a moment and ask you a bunch of questions. She'll ask each question just once. So she'll say, state your name. And then she'll say, Mr. Rogers and Mr. Mender. She'll go in the same order each time. And so when you hear your name, whatever your answer is to that question, yes, 19, 32, whatever it is, please share your answer. And then she'll turn to you, Mr. Mender, and not repeat the question. She'll just want your answer to what that question was. If you don't remember what the question was, let us know, and I'm sure she'll repeat it. Does that work for you, Mr. Rogers?
Yes, sir.
Does it work for you, Mr. Mender?
Mm-hmm.
Okay, I need you to say yes or no, or I don't know, no mm-hms, okay?
Yes.
All right, good. Ms. Davis, when you are ready.
Please raise your right hand. Both of you. Okay. Do you swear or affirm that the testimony you will provide today before the court will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes. Yes, ma'am.
Okay, thank you. Mr. Rogers, please state your true and correct legal name.
Monte Rogers.
Can you,
Monte Jamal Rogers.
can you spell your first and middle name for the record?
My first name, Jermonta. You spell my last name,
Your middle name?
Jamal.
Okay, thank you. And you can put your hand down. Mr. Mender, please spell your, state your true and correct legal name and spell it for the court.
QUANARDMENDER.
Okay, and what's your name?
Bernard Mender.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine, Mr. Rogers?
No, ma'am.
Mr. Mender?
No, ma'am.
Is there any medication that you normally take that you have not been given today, Mr. Rogers?
No, ma'am.
Mr. Mender?
No, ma'am.
How old are you and how far have you gone in school, Mr. Rogers?
I'm 14 and I'm in high school, 9th grade. Should go in 10th grade.
Mr. Mender?
15 and I'm in the 10th grade.
Mr. Rogers, did you say you're going into the 10th grade or you said I should be in the 10th grade?
going to 10th grade.
Okay.
Mr. Rogers, what high school were you attending?
Washington High School, Booker T. Washington.
Mr. Mender?
Going to Banneker.
Say that one again.
Banneker High.
Banneker.
Are you able to read, write, and understand the English language, Mr. Rogers? Mr. Mender?
Yes, ma'am.
Are you a United States citizen, Mr. Rogers?
No.
Yes, ma'am.
Do you understand that you are charged with the following offenses for Mr. Rogers in 25 SC 000816? The state is moving to null pros or dismiss the armed robbery count, and we are proceeding on count 2, aggravated assault, and count 3, possession of a firearm during the commission of a felony. Do you understand that's what you're charged with, Mr. Rogers?
Yes, ma'am.
Mr. Mender, in 25 SC 00816, the state is moving to null pros the armed robbery count. The state is also reducing the aggravated assault count to reckless conduct. That is OCGA 16560, which is a misdemeanor. And the state is moving to null pros the third count, possession of a firearm during the commission of felony. Do you understand that?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Francis and Ms. Cabrera, about all the facts and circumstances known to you regarding the charges of this indictment, including any potential defenses?
Yes.
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
No, ma'am.
Are you satisfied with his and her services?
Yes, ma'am.
Yes, ma'am.
Attorney Francis, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Do you remember having been arrested on these charges?
Yes, ma'am.
Yes, ma'am.
Judge, the state is unaware of any outstanding warrants related to these charges. Attorney Francis, are you aware of any outstanding warrants related to this matter?
No, I'm not.
Has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today, Mr. Rogers?
Yes, ma'am.
The maximum, well, the sentence timeframe for aggravated assault is 1 year to 20 years. Possession of a firearm is 5 years consecutive. Mr. Mender, the sentence maximum is 12 months. Are you aware of that as well?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Yes, ma'am.
Do you understand the court has a right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Yes, ma'am.
Time to break this one down. This hearing was a mix of formalities, teenage nerves, and some careful judicial coordination. We had 2 young defendants, Mr. Jamal Rogers and Mr. Bernard Mender, standing before the court to enter negotiated pleas. Representing them both was Mr. Francis, who did double duty for the day with the court's approval. Mr. Mender's original attorney, Ms. Cabrera, couldn't make it, but her colleague stepped in with prior agreement on the record, and everyone, judge included, seemed on board with the arrangement. To his credit, Mr. Francis was calm, direct, and kept both clients' interests in view. The judge was thorough and fair throughout, asking thoughtful questions, double-checking that both young men understood what was happening, and showing patience as they worked through the process. It was a textbook example of courtroom diligence, but with a few revealing human moments. Both defendants, teenagers at 14 and 15, answered the judge's questions politely and clearly, though there was a gentle reminder to respond verbally and not just nod. Mr. Rogers, who attends Washington High in Portsmouth, and Mr. Mender, a student at Banneker High, were appropriately serious. They affirmed their understanding of the charges, the nature of a negotiated plea, and the potential consequences. The judge took extra care to ensure they weren't under the influence of any medication or pressure, and that they felt adequately represented important steps given their age. From a legal perspective, things were shifting significantly. For Mr. Rogers, the state dropped the armed robbery charge, moving forward instead with aggravated assault and firearm possession during a felony. That firearm count carries a mandatory consecutive 5-year sentence, which wasn't lost on the court. Mr. Mender, however, saw his aggravated assault count reduced to reckless conduct a misdemeanor, and the firearm count was dropped entirely. The contrast in charges and consequences was stark, but each plea was tailored to the individual's role and circumstances, and both were handled transparently. The courtroom atmosphere was serious but calm, with a clear focus on making sure the young men understood the gravity of the situation. Ms. Davis, for the state, moved through her questions efficiently, and credit goes to her for keeping things clear and concise, especially when directing the questions jointly. No theatrics here, just a careful step-by-step review of rights, charges, and responsibilities. And while we didn't see any dramatic outbursts or objections, the undercurrent was clear. This was a chance for both young men to redirect their futures. One small but telling moment came when Mr. Mender was gently reminded to say yes out loud rather than simply nod. It was a subtle cue that despite the serious legal context, these are still kids navigating an adult system. The court didn't treat them with kid gloves, but it did show just enough flexibility to balance accountability with understanding. So, no fireworks, no chaos, but a meaningful and well-handled hearing that might just mark a turning point for two young lives. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.